Good afternoon, everyone. Welcome to the October 29th, 2019 meeting of the Texas Industrialized Building Code Council. I'd like to call the meeting to order. First point of business is a roll call. Answer when asked. Randy Childers. Here. Suzanne Arnold.
Here.
Brian Bailey. Brian Bailey. Janet Hoffman. Janet Hoffman. Robert Lesu. Robert Lesu. Edward Martin.
Here.
Scott McDonald. Scott McDonald. Marcella Rhodes.
Here.
Douglas Robinson. Douglas Robinson. Stephen Shang.
Here.
William Smith. William Smith. Okay. With that, I believe we do not have a quorum.
That is correct.
So we will proceed with the meeting, but we cannot vote on any official business. With that, since we cannot vote on the business, I would say that we table the approval of the minutes for the next meeting.
Yes.
Does that work? Since there is not a quorum, there would not be need, or would they be need for public comment?
Mary Winston, TDLR, if we had any, and I don't think we do, we don't have any forms, but if we did, we would take public comment.
Okay, so if you're here for public comments, there should be some forms on the table as you went in. We would appreciate you filling out those forms. Okay. That moves us on to item E, presentation and discussion regarding the role and responsibility of the council, department, and commission. Presentation and discussion regarding the department's enforcement authority and consumer protection. This was a request from our last meeting, so we can better understand our role in protecting the citizens of Texas within our area of authority. And Molly, before you get started, if I can, for members of the council who are here, if you have a question or a comment, please let me know, and before you speak, tell us your name so it can be picked up and recorded properly. Thank you. Molly, go ahead. Thank you.
Thank you very much. My name is Molly Feudel. I'm an Assistant General Counsel here at TDLR. I'm going to be giving the first half of the presentation, and then I'm going to hand it off to John Medlock from Enforcement, and he's going to give you some detail about that. So my presentation today is going to be about the role of the council and the roles of the commission as well as the department. We thought this would be a good opportunity to give some of the newer members of the council some context as to where your responsibilities fit in with the department and the commission. So the Commission of Licensing and Regulation governs the Department of Licensing and Regulation, TDLR. The commission is made up of 7 members who are all appointed by the governor, and by law they cannot have any participation in an industry that's regulated by TDLR. So they can't own a tow truck company, for example. They can't be a manufacturer of industrialized housing and buildings. The commission appoints the executive director, and the executive director runs the department, which administers the programs. IHB is one. So a good way to think about it is that the commission does the big picture items, policy making, and the department carries out the day-to-day functioning of the department. So by statute, the commission develops the policy goals for the department, appoints the executive director, approves a budget, legislative appropriation requests, that kind of thing. And the executive director makes sure that the department is running and hires personnel to fulfill the duties. So this is an example. in terms of issuing licenses. Licenses are issued by the department. So the department receives the application, makes sure that all the prerequisites have been met, processes a payment. But in terms of the big picture, so the term of the license, the fees, any continuing education that's required, that's set by the commission. So you as the council have a unique and important role in the functioning of the IHB program. You have a bunch of duties that other, advisory boards do not have. So for example, you establish criteria for approval of the third-party inspectors and the design review agencies, the DRAs. And your duties fit hand in hand with the department because the department recommends qualified people to you and it grants interim approval. You approve them and then the department publishes a list of people who have been approved. Another one of your duties is you issue a stamp of approval that's put on, the DRAs put on all the paperwork that's approved to the approved plans. You also establish procedures for inspecting industrialized housing and buildings. And then the department can, of course, conduct the inspections or use third-party inspectors. You also determine certain questions, so questions raised by municipalities or questions concerning alternate materials and code equivalency. And your decisions and interpretations are binding on the department and municipalities, DRAs, third parties. So you also have a very important role in rulemaking, and we'll present some rules to you later today. But the department proposes rules to you. You review those rules and then vote to publish those rules in the Texas Register. Then the public has an opportunity to comment, and then the department then brings those comments and the proposed rules back to you for a review. And you recommend that the commission adopt the rules, or you can recommend changes to the rules based on those public comments. You also adopt amended building codes, and we do that through the rulemaking process. So according to the IHB statute, the commission adopts rules as appropriate to implement your actions, also to regulate manufacturers and builders of industrialized housing and buildings, also adopts rules regarding decals and insignia and reciprocity. So I'm going to give you just a high-level overview of enforcement because John's going to give you more detail on it. But essentially the department and the commission carry out enforcement of the IHB rules and laws. The commission establishes what's called an enforcement plan, which contains a penalty matrix for every program. So there's an IHB penalty matrix, and the penalty matrix has a list of all the possible violations within the program with a range of penalties. And when I say penalties, I mean fees, essentially. So you recommend that penalty matrix to the commission, and then the commission will adopt it or make changes if they see fit. As for the actual duties of enforcement, the department carries out those. They receive complaints, they investigate complaints. If they believe that there was a violation, they issue a notice of alleged violation to the respondent. That's what we call the person who we believe committed the violation. And they will negotiate a settlement if they can. The executive director issues agreed orders and default orders. A default order is if somebody just doesn't respond to the notice of alleged violation. If somebody requests a hearing, the department will take the case to the State Office of Administrative Hearings. They'll hear the case, and then it will go before the commission, and the commission will make a final determination. So there are some tools at the commission and executive director's disposal. They can assess the administrative penalties, the fees, fines. They can sanction a license, so revocation, suspension, probated suspension. And the executive director can also issue cease and desist orders or seek an injunction in district court to get an order to order somebody to stop doing something. So there's also a criminal history aspect to enforcement. whenever somebody applies for a license, almost every license has a criminal history background check that goes along with it. And so the license can be denied for criminal history, or if somebody lacks the honesty, trustworthiness, or integrity to hold a license. The council, you guys recommend criminal history guidelines. So that would be the types of crimes that might disqualify somebody from obtaining a license. And then those guidelines go before the commission, and the commission will vote on them. So to give you a quick summary of your responsibilities, you have the IHB program-specific duties, like approving the DRAs and the TPIAs, and determining questions concerning the code. You also have your rulemaking duties, and that includes updating the mandatory building codes, adopting a penalty matrix. There is one adopted, but you can update it at any time, and also the criminal history guidelines. So that's all I have, so I'm going to turn it over to John.
Thank you, Molly. Again, my name is John Medlock. I'm a senior prosecutor with the Enforcement Division. I know a lot of concern from the last meeting was what can we do to help consumers and protect consumers. I'll get into that here in a little bit, but I think first it might be better for you guys to understand what it is that the enforcement actually does, and like how we're divided, and how a case goes from our intake division all the way to the decision that the prosecutor has to make. So kind of with that, our enforcement division is divided up into 3 different sections. We have an intake section, an investigation section, and a prosecution section. And I'll kind of talk about each one of those different roles real quick, and we feel that this setup is kind of like mirrors what the life cycle of the case is. And then when I'm talking through, you'll kind of see what I'm talking about in that regard. So to that regard, our intake section is where everything comes in, all the complaints that come into the department for all of our programs. And right now we have 43 different programs that we look over and regulate. That's where they all come into. In that regard, our intake section basically, and what Ms. Clark is passing out, is kind of like the flow chart that we've developed, so you can kind of see the process. It's just kind of a substantial flow chart, so to put it up on the screen, so it may be better for you guys to take a look at it. But the intake section, once they get a complaint, typically a lot of them, we try to push a lot of it on our online system, but we would take them by paper, fax, phone. But what their first job is to do is to look at that complaint and determine a couple of things. One, see if that's a program that we regulate, because sometimes we do get complaints on industries or programs that we just don't regulate, so we have to close those. But if it is a program that we regulate, then the next thing they have to decide is whether or not we have jurisdiction over that. Sometimes, like in the AC program, somebody might have gotten overcharged for an AC system, and so everything's working fine. There's no other allegations that anything was wrong with the installation, but they just felt they got overcharged. We don't regulate price in the AC world. So that's a complaint that we don't have jurisdiction on. So that's kind of what they do. So once they basically have answered those 2 questions, is it a program that we regulate, and is it something that we have jurisdiction over, then it moves to the next step in the process, and it goes from being a complaint to now an open case. And so they will have assigned a case number, and it'll go over to and be assigned to one of our investigators. Now, the investigator's role typically is to ask the kind of the who, what, when, where, how questions. They are supposed to be neutral fact finders. They will typically talk to whoever the complainant is. They will talk to the respondent, and if during the course of their investigation, they'll find if there are other parties that got involved, they'll talk to those people. They'll gather all the documents. Sometimes, typically it's just paper documents, but occasionally it can be actual physical photographs or even a physical piece of equipment, and we'll lock that up in our we have a little small evidence area, but typically it's mostly documents, and so we'll upload that into our case management system, so everything is, for the most part, is electronic that we do. But they'll gather all that information, the stories from the different people, and they'll put that together in what we call our investigative report. Now, in that investigative report, we don't want them that seek an opinion, oh, I think the respondent was, doing wrong in this, or I think the complainant doesn't have a case. We don't want that kind of, opinion into it, because that's going to be the prosecutor's job, is to kind of weigh that evidence and determine whether or not there is a violation. But the investigator will go through and collect that and write that narrative, essentially. Occasionally, in some of our programs, we'll have to seek the assistance of expert witnesses. We recently got a lot of health programs from the Department of State Health Services, like podiatrists. We don't have a podiatrist on staff, so we'll have to seek outside members and podiatrists to review the medical evidence, determine whether or not there was a standard of care violation. In the AC world, we actually have a couple of people on staff that are actually ACR contractors, and we'll send them either out to the job site to review the installation, see if it was done correctly. Maybe they can review some pictures, and they'll give us that expert opinion. In this program, the our IHB staff, headed by Donna, they'll send out people to do on-site inspections, and then they'll give us that report that the prosecutors will use and review to determine whether or not there are violations. So once all that gets compiled and expert reports and then the investigators' reports get concluded, then it moves over to one of the prosecutors. Myself and one other prosecutor, Robert Reyes, actually review all the complaints that come into this program. So between the two of us, we kind of handle the bulk of all these cases. So what we look for is, we read all the evidence and we look at the different reports that come in and determine whether or not a violation of one of the laws or rules has applied. And essentially, when we're looking at these decisions, we've got about one of three choices that we can make. And you'll see that there's a lot of threes in kind of what I'm about to describe in kind of some of our decision making. So the three main categories of things that we can do is we can close the case, we can warn on the case, or we can issue a notice of alleged violation. So if we're going to close a case, typically one of the main reasons that we close any of our cases across any of our programs is because there's just not sufficient evidence. There might be a complaint that might allege some wrongdoing, but during the course of the investigation, there just wasn't the evidence to substantiate that there was a violation of the law and rules. So we'll just go ahead and close that case for insufficient evidence. Now, occasionally in some of our programs, there is a violation, but maybe the respondent has taken corrective action, either pay the customer back for an AC system that was not correct, so they can go get somebody else. Maybe they went back and repaired the system, something like that. So maybe it might be what we call an informal resolution. We'll close the case that way because maybe the consumer is happy, the respondent has made corrective action, so there's no really need to take that case forward because essentially, the thing that was complained of was fixed. Occasionally, there'll be a situation where the complainant will just say, you know what, I'm not interested in pursuing this case anymore, and I just want to withdraw my case. It could be for a myriad of reasons. It could be maybe before we even knew about it, the respondent came back in and fixed the system or corrected whatever the issues were. It may be that they just aren't interested in prosecuting the case and going forward. So they'll just, we'll close that case as a complaint withdrawn. Now, the next kind of category of way we can close a case is we can close it with a warning. Now, typically, when we close something with a warning, that means that we have found a violation of a law and rule, but maybe it was not something that is directly related to consumer harm or public safety. It might have been a technical violation. Maybe they forgot to include a license number on a website and they went back and corrected it. Yes, it is a violation, but they've gone and corrected it. So we're just going to issue a warning. Hey, just make sure you keep up on your P's and Q's and that you don't do something like that again. So that's kind of another issue. And we usually use those for our smaller ones, but it's always on the table for us as a tool for us to hopefully get some corrective action on the part of the respondent. Now, the final tool that we have, essentially, of the three decisions we have, is a notice of alleged violation. After reviewing the evidence, seeing the different stories, if there was an expert report, reviewing that expert report, the prosecutors essentially decided, you know what, there's a violation here, and so we're going to issue one of these notice of alleged violations. So when we do that, we'll draft the allegation paragraphs, and we look to our enforcement penalty matrix, like Molly described. Each one of our programs has a different penalty matrix, and essentially what we've done is taken all the laws and rules in that program and put them in different classes of violations. Each class represents kind of similarly situated violations. Like Class A are going to be your least serious. Usually Class D are your most serious and most egregious. And as such, the penalties increase throughout the different classifications. Some of our programs have a single range where it'll just be like in ACR we just recently went to this where it'll be a 2,000 in a Class C violation, like 2,000 to 5,000 with some sort of a license sanction. Now, other programs used to have like a first, second, and third violation. IHB still is under that kind of philosophy right now with our enforcement penalty matrix. So we have a Class A, first violation, Class B, second, and third. And within each class and each subsequent violation, the penalties increase and the sanctions increase. And you guys actually have a lot of different penalty matrix. You've got one for the builders, you've got one for the manufacturers, the design review agencies, the reefs. So, I mean, it's a lot more than, typically we just have one penalty matrix per program, but you guys have a lot of different people underneath your purview, so we have a lot of different penalty matrix that we can use depending on the type of case that it is. So we'll draft the violations and we'll look at whatever the statute is that's being, or statute law is being violated, and we'll go to that classification, a penalty matrix, and determine what the appropriate penalty is for that particular violation. That'll get all put together in a notice of alleged violation, and it'll get sent to the respondent. Respondent has about 20 days. We usually give them a little bit longer, but they have 20 days to come back to us and say, hey, at this point, they've got about one of three choices. They can say, you know what, I'm in violation. I'm going to sign the settlement agreement that we always attach on the back of each one of our notice of alleged violations and call it a day. They can not respond to us at all, and then we're probably going to start going down that default track, and I'll explain a little bit more about that here in a second. The third thing is they could request a hearing. So let's go back to that first one. Let's say that they decide to go with an agreed order. Each one of our penalties, or each one of our, anytime we decide to assess and allege a violation, we include two penalty amounts. The full penalty, which is always what we're going to be seeking at a hearing, but we also know that if we submit a reduced penalty, usually it's always 75%, we can probably get settlements quicker because we get a high volume of cases throughout all the programs that we regulate, and so we can't always just be sitting trying to negotiate. So we encourage settlements by offering a reduced penalty. And like I said, just to make math simple, let's say we issue a $10,000 penalty. The reduced penalty is going to be $7,500. And on the back of that notice of alleged violations will be a settlement agreement that they have the option to sign, basically saying that I'm admitting to the violations, I'm waiving my right to a hearing, and I've enclosed my my penalty of $7,500. That will, if we receive that, we'll get the signed settlement agreement back, and we'll get the money, and we'll reduce that into an agreed order, which Brian Francis, our executive director, will sign off on. In the second case, let's say that we've issued the notice of alleged violations and we don't hear anything back from the respondent. No email, no phone call, no written correspondence, nothing. Well, after that time frame has passed for them to request their hearing, we'll give them another chance. We'll send in a notice of default saying, hey, we're about to default you in this order for the full penalty, not the reduced amount. The full penalty is about to go into effect against you unless you respond to us. We give them additional time for that. If that time passes, then we'll go ahead and reduce that down to a default order. And then, again, we'll send that over to Mr. Francis for him to sign off on that default order, and then that order will become effective on the date that he signs it. The last option that they have is they can request a hearing. All hearings that are requested from anybody in any of the programs that we regulate go before the State Office of Administrative Hearings. We'll docket that with them. It typically takes about 3 months for a hearing from the date of request, just because, again, the State Office of Administrative Hearings doesn't just hear our hearings, they hear pretty much every office, every state agency's hearings. So they're obviously a very busy agency in their own right. So when the day for the hearing comes up, it's basically like, it's what it is. It's a hearing. I mean, there's an administrative law judge. The rules of evidence apply. So the department has a burden, and it's by a preponderance of the evidence that we have to prove the allegations that we're alleging. And we'll bring expert witnesses if need be, our investigators, the complainant, any witness parties. We'll introduce all that stuff and to try to prove our case. The respondent obviously has the exact same opportunity. They can appear pro se, which means that they don't have an attorney, or they can have a represented counsel. The one kind of unique thing about the SOA is that it's always before an administrative law judge. There's no right to a jury at that proceeding. And at the conclusion of that hearing, they'll typically take closing arguments. Sometimes they'll want it by written submission, but typically it's closing arguments. The ALJ then has essentially 60 days to write what they call a proposal for decision. And that's kind of what the way I like to say it is, based on what they have heard, the evidence they've heard, and the documents and the witnesses, this is what they believe happened. And it's their proposal for decision. It's not a binding decision at that point in time. They draft what they call findings of facts and conclusions of law. And I, again, kind of like to say, they have about 3 choices. They can say, state or department, we think you carried your burden and the penalty that you requested is appropriate. That's what we're going to assess. Department, we think you carried your burden, but the penalty is a little too high. We're going to go ahead and reduce it. They never go up. They always stay at whatever you ask for, go a little bit lower. And the third thing they can say is, department, we don't think you carried your burden at all. And so we don't think that any administrative penalty should be assessed, and the respondent essentially had won the case. So that's kind of what their PFDs kind of usually look like. At that point in time, there is an opportunity for both sides to write what they call exceptions to the proposal for decision. It's kind of like each side is basically saying, hey, judge, we think you got it wrong on this finding of facts, you misinterpreted this, or we think you interpreted this conclusion of law wrong. And then that will go again before the ALJ, and then they'll make a ruling or make any changes necessary. Once all that part has been wrapped up, then it'll go, like Molly said, before the Commission on Licensing and Regulation. I like to call it kind of like giving the commission like a Reader's Digest version. We'll present our side and kind of like a little, 2-minute kind of like spiel of like, this is the day we had the hearing, this is what happened, this is what the judge found. And essentially we will either ask for them to adopt the proposal for decision or ask them to amend it in some way, shape, or form or fashion. And the respondent has that same opportunity to give kind of their side of the argument. The commission on that day will vote to make a decision on whether or not they want to adopt that PFD or not. And then that's kind of how that's how that commission order kind of, that process kind of finalizes at that point. So now that's kind of all the tools that we have, or kind of the way the process works. So let's talk a little bit about what do we do when we get one of these complaints, and how do we go about protecting the consumers with the laws and rules that we have. The first thing I would like to say is the good news is that the vast majority of the people in this industry are doing it right, because we don't have a whole lot of complaints in this program compared to some of our other programs, which to me is always good news, which means that most of the time that somebody is purchasing or building one of these homes, they're doing it the right way. And I think that is something that needs to come across. It's only when something goes wrong that we see it. And again, like I said, in the vast majority of it, based on the number of like decals and insignias that are issued on a yearly basis, the number of cases that we open on a yearly basis is significantly low. So I think that's some good news and kind of something to take a hold of. Now, again, what do we do to help consumers? So like I said in the process is we engage with our RPM staff in the IHB program. When a consumer says, hey, you know what, something's wrong with this modular home that I just purchased. Maybe the windows are leaking, the floor's not level, something's just not right. They'll submit that complaint. It'll go into intake and all the way through our investigation. Our investigators will reach out to Donna and her staff and say, hey, can somebody go out there and take a look at this house? Now, their staff does a fantastic job when they go to do these on-site inspections. They'll take the complaint and look at it, but they don't just look at what the person is complaining about. They'll do a whole inspection of everything from ground up, and the level of detail and just the reports that we get from them are amazing. So I want to compliment our staff on doing a great job of that. Matter of fact, to the point where when we started getting experts in some of our other programs, we actually had them start using their templates in the way that they did stuff on their expert reports because it just was so good. There's pictures, there are code sites, there are brief narratives with every one of the issues that they find and when they go to do these on-sites, and it makes my job so much easier because I can just go through and say, oh, this is a builder's issue, this is a manufacturer's issue. And it just makes it, when I'm drafting a notice of alleged violation, just so much easier. And so I really do appreciate that. So that's kind of the first step is when a problem comes in, we send somebody out there to go take a look at it and get that inspection report. Now, the next thing is usually when there's an inspection report, we'll go ahead and issue that notice of alleged violations. And part of the reason that we issue that notice of alleged violations is not because we don't want the consumer to have their house fixed or the issue to be resolved. There's a statutory timeline that we are under. And I believe it's actually, I have it written here. It's 1202.107. It's called Limitations on Certain Actions. It basically says that from the date of a final inspection on one of these buildings, if 2 years passes and we haven't had a complaint or initiated an investigation, and the one that we've taken to heart, initiated an administrative or enforcement action. To us, that means issue the notice of alleged violation. If we haven't done that within the 2-year period from the date of the final inspection, there's nothing legally we can do to help the person. Matter of fact, we actually have to close those types of complaints. So there's a little bit of a time pressure. And so typically, it might take a year sometimes for something to pop up. So sometimes we've got a year time frame to get out there, to do the inspection, and to get this notice of alleged violation out before we can even try to do something. And like I said, the reason we issue the notice of alleged violation is for the reason that if we don't, and we just try to engage with the person to try to get corrections made at the house, and that 2-year period lapses, well, we've lost our opportunity to do anything if they've decided to back out and help that consumer. So we always want to make sure we issue that notice of alleged violations to, I don't want to say hold their feet to the fire, but at least, make sure that we've got a check and balance on if they say they're going to do something, that they really are going to follow through with it. So again, once we've issued that notice of alleged violations, that usually spurs a call into either myself or, like I said, Mr. Reyes, and I'll talk with the builder or the manufacturer, whoever the case is against, to say, hey, look, here's what I really care about. I care about compliance. I care about getting this consumer the product that they thought that they were purchasing. So let's go through this. Let's go through the different violations. Let's go through the inspection report. Make sure, do you have a copy of the inspection report? If they haven't gotten it, I make sure they get a copy of it. It's let's go through this. Let's see what corrections we can get made. And I almost use it kind of as a punch list in the sense that, okay, let's say we have 10 different violations. Well, once they go through and they say that they've corrected, and again, I'll make sure I'll verify with the consumer that it has been corrected, I'll mark that violation off. And I'll go through all those violations until they all, get them corrected. And 9 times out of 10, they'll be happy to go through and get all the violations corrected. So if they've gone through and corrected all the violations, I'll close that case. And so there won't be a disciplinary action against that person because they've gone back and they've shown me that they have taken the steps necessary to remediate whatever the issues were. So that's one of the things that we typically try to do. And that's one of the things that we strive to do the most. That's also why there's very few administrative orders, either through a default or an agreed order, that you guys are presented when you guys have your meetings in our, in these different meetings. Now, I know one of the concerns was, well, what happens if, the cost of doing business, it's easier for me to write a violation, to pay this versus correct it. That does happen occasionally. Unfortunately, the way the laws and rules are structured, there's nothing that we can do to order them to correct the situation or pay restitution. We don't have that authority in this program to do those things. So that's why we try to engage with them on the front end to try to get them corrected. There are situations where we might have somebody who doesn't want to correct an issue and they just would rather pay it. Okay, well now, guess what? Depending on the level of violations, that's your first violation. If down the road we see you again and again you have decided that it's easier for you just to pay the violation versus make the corrections, well that's now a second violation. And as I said earlier, every time the violation increases, not only does the penalty amount increase, but also the implementation of license sanctions. Molly's right. We have the ability to suspend somebody's license, and probate that suspension, which is kind of the least severe sanction in the sense that we can say, hey, we're going to suspend your license and you can't work. However, we're going to probate that suspension. So we're basically watching you. So if we get any other complaints, we're going to open an action to try to enforce a sanction against you. That's kind of the least severe sanction. We can fully suspend somebody's license. The most severe is obviously we can revoke somebody's license from operating. And if we take that route, that means that the date that the revocation is effective, they have to sit out for 1 year. They can't even apply for a new license until 1 year from the date of that original revocation. So it's obviously a pretty severe sanction. Again, there are, and a lot of times it's in some of our other programs, but if somebody's really egregious, we have the ability to, again, issue cease and desist. If we need to, we'll work with Molly's over in General Counsel's office to maybe seek an injunction and go to the AG's office to essentially bar someone from being in that industry. That's one of the more severe things that we can do, but it is one of the tools in the toolbox. So we do have a lot of different things that we can do. Again, our focus is on trying to, as I told other kind of programs that I care about compliance more in the sense that I can find people all day long. It's not going to get somebody's house correct. It's not going to get somebody's building correct. I care more about that than I do enforcing the administrative sanction against somebody. I'd rather have someone get the product that they purchased versus just racking up an administrative penalty against somebody. So that's kind of where we kind of are, and this is kind of what some of the things that we try to do to help people and the different consumers. So if you guys have any questions, I'll be happy to answer them.
Counsel? Thanks, John. I do have one question. Relative to whenever the respondent is notified of the concern, are options given to that person? Because normally they have no idea of the procedures,
Right.
of the steps on your side. So they're going to sit there, and I'm guessing, I've fortunately have never been involved in one of these, but sitting there going, oh my goodness, what options are available to me?
Right.
And who should I get involved? How do I protect myself? Can you give a few moments on the
Absolutely.
thoughts there? Because they need to be protected too under the
Absolutely.
right circumstances.
Absolutely. Every one of our notice letters includes paragraph and language that says, get in this is what could happen if you don't respond to us, if you don't get in contact with us. If you would like to get in contact with us and request certain different things, here is the number. So we always have our number and our contact information. Again, 9 times out of 10, people get in contact with us. That is our opportunity to educate them and let them know. It's like, look, okay, yes, you have this notice letter out there. Here's one thing you can do. You can say, you know what, I'm going to fight this and I want to request a hearing. And then that spiel that I just kind of gave you about, I give that to everybody that calls me, whether they be the consumer, whether it be the respondent. I say, hey, look, this is what the processes are. This is what you can expect. My legal assistant does the exact same thing, and all the other prosecutors. That's kind of what we tell everyone, is just that when they get in contact, reach out, let them know what all the different options are. We also let them know, it's like, hey, look, especially in this program, here's what I would like to happen. I would like for you to address each one of these issues that are cited in the notice of alleged violations, and let's go see if we can make some corrections. Because if you go out and make the corrections, I'm going to probably knock off that violation. Now, we'll discuss how that's going to happen and time frames and all that goes into doing that. So it's usually that when they get that notice letter, there's information in there to contact the department. It frankly says contact the department, and we want that to happen. So if anybody's listening to that, if you've gotten one of these letters, please get in contact with us, because if you don't get in contact with us, that's when we're probably looking towards going that default route. And a little bit about the default. So, and this goes with all of our programs, that penalty will stay. And the department will try to collect on those things. We don't just let them stay stale and just not try to collect on them and write them off. The department will engage with some kind of debt collection activities. If the penalty amount is high enough, we'll actually refer it over to the Attorney General's office as well. Now, if the person is actually a license holder, what we'll do is also put like an enforcement hold on them. So the next time that they go to renew that license, they can't renew it until they start making either some sort of payment on that administrative penalty or pay it off. So again, contact the department. That's kind of the main thing, and then that will help get those conversations started and where we need to go to try to get these things fixed and corrected.
And I would assume this is really the first level. The consumer still has the ability to file
Absolutely.
Suit in civil court, correct?
Absolutely. And I always tell consumers that, is that, look, don't wait on us to get either a default order, an agreed order, or even if they request a hearing commission order, because that can sometimes take time. The commission, going through the commission process can take, from original complaint to final commission order, can sometimes take almost a year, just because depending on different dates and times. So no, I always tell people, it's like, look, you have the avenue to go into either a district court or a JP court and seek, solutions there. What we do is not going to be, like, if we don't find anything, that doesn't mean that you're not going to get something at a JP court or a district court level. So that is always an option and avenue, and we always tell people, it's like, we can't advise you because we're not your attorneys, but that option is always available to you as well.
And I'm sure it's hard for a respondent to look at you from a beneficial standpoint, but in that aspect, it is a benefit to them if
Right.
they look at it correctly. Yes, ma'am.
I'm Marcella Rhodes. I know I'm familiar with enforcement and other departments where there's certain things that are listed on the website
Yes.
under that project or that maybe a case.
Mhm.
Is it the same thing with this? Is that
Are you talking about,
available?
like, if you want to go out and look to see if there's been an administrative order against somebody?
Or what the results have been, or what do you guys?
What we do on our website is there is an administrative order search, and so if there's been an administrative order, whether it be a default, agreed, or commission order, that information is available on our website, and you can search that. If it's been one of these warning letters or a closure letter, that's not going to be on the website. It's only going to be on those orders that you can be able to find that information.
Any additional questions? Yes,
Randy
Randy.
Childers. I have a couple, John.
Hmm?
At the top of the second page, you said no further action is taken.
Oh, on the
To the
flow chart,
complaint.
yes.
If there's some sort of additional evidence, does the department look at that and potentially
So-
reopen or open if some other
Yeah.
information becomes available?
Yeah, that does happen from time to time. So a lot of times what will happen is sometimes the complainant will be really gung-ho at the very first and provide a basic amount of information, and then they might have dropped off during the course of the investigation. And by the time it gets to my desk, it might look like the respondent has been more proactive in dealing with us, and so it may look like the evidence, well, wasn't quite there to sustain this violation. So we'll close the case. Every time we close the case, whether warning or any type of closure, letters go out to both the respondent and the complainant. So sometimes that will trigger that complaint. It's like, oh, wait, I've got all this other additional information. Well, I always tell people, it's like, well, when you talk to the investigator, give them everything that you think might be pertinent. There might be things that you don't think are pertinent that I might think are pertinent, and vice versa. I would rather have more information than less information to make a decision, because when I'm going through and making these decisions, I'm essentially in a vacuum. I mean, what I have in front of me is what I have to review. And if there's a bunch of stuff that y'all are holding on to on the outside, I don't know that when I'm making my decision. So yes, occasionally we'll close a case, and there may be like, oh, wait, here's this treasure trove of information. Yeah, we'll go back and tell them, either if it's within a certain time period of closure, we can go ahead and reopen it. If not, we'll say, hey, file a new complaint. We'll dump all the old documents in there. We might even open the case ourselves, and then just dump all that stuff into it and go through the process again.
My second question was in your example of the $10,000, 75%.
Mhm.
So respondent pays the $7,500. What happens to the violations? Because I assume they have not been fixed.
Correct, yeah. At that point in time, they have essentially, in this case, have made the decision that I'm not going to correct any of the violations. And that's the issue that we run into with a lot of our building and mechanical type programs, is that sometimes it might be more cost effective for them to not correct it. It may just cost more for them to correct it than it would be to pay for the penalty. And again, we have a statutory cap of $5,000. And the way that this penalty matrix is structured, we have certain limits, and those are binding on the prosecutor. So whatever the limits in the enforcement plan are, that's what we can deal with on each of these violations. But again, if this is a repeat offender, if we're hitting the third violation, that actually goes up to per day violation. So at that point in time, if this person is a really bad offender, those penalties can get really, really high, because depending on if the final inspection was on, let's say, January 1st, and we're not finding out about it until September, there's 9 months worth of per day violations of ongoing that they haven't corrected it. So. Okay.
Molly, John, thank you very much.
Thank you.
At this point in time, we move on to staff reports.
Presiding Officer Brown, the first staff report we have is for the licensing division, and I'm going to give that Mary Winston TDLR for them. So if it's okay with you, I'll just stay seated.
That'll be fine, Mary,
Okay.
thank you.
Okay. Today, we have, for the licensing report, we have numbers from fiscal year 2016 to date for manufacturers, builders, third-party inspectors, third-party inspector agencies, as well as design review agencies. The numbers to date appear on target and pretty much holding steady. If you take a minute to review these things, I can take any questions you have back to our licensing division.
Randy Childers. Mary's, the state's fiscal year is August or September?
September 1.
September 1.
Mhm.
Okay.
Any other questions for Mary? Mary, thank you.
Okay, thank you.
I guess we go to the consumer, or customer service division next.
Good afternoon, advisory board members. My name is Tuan Nguyen. I'm one of the managers for this program in customer service. So I just have another quick update for y'all since the last time we met in June. The web forms are working really well for this program. Most of our emails are still being sent over to the RPM group. We haven't heard any questions on our phone calls. Most of our phone calls from our stats is still basically from website navigation. We're just navigating the customers to a lot of the forms and certain questions, and a lot of it's still going straight to the RPM group. Other than that, if you have any questions for me, I'm very happy to answer them.
Yes, this is Roland Brown. If I may, what type of inquiries do you normally get?
Just
general.
general inquiries would just be more like, I need help finding this form, and then we'll sometimes email the forms to the customers. And sometimes they will have a very technical question, and then we'll point them the direction to send in a email request, and then it'll be routed to our RPM group.
Okay. All right. Council, any questions? Thank you. That was
You're
quick.
welcome.
I guess we go to the enforcement division now.
Good afternoon, council members. My name is Morgan Cumming, and I'm a prosecutor with the Enforcement Division, and I will present the Enforcement Division's staff report to you today, which is on page 9 of your documents. I will discuss the statistics derived from the division's regulatory actions over the past 2 fiscal years, so as to provide you with a general overview of enforcement activities. 23 cases were opened in fiscal year 2019, which began on September 1st, 2018, and ended on August 31st, 2019, compared to 18 cases were opened in fiscal year 2018, which began on September 1st, 2017, and ended on August 31st, 2018. 15 cases were closed during fiscal year 2019, compared to 24 cases in fiscal year 2018. During fiscal year 2019, 1 case resulted in a final order which assessed a penalty of $13,500, and the department collected the full amount of $13,500. While in fiscal year 2018, 3 cases resulted in a final order which assessed a total of $15,250, and the department collected the full amount of the $15,250. As you can see, the statistics for these 2 fiscal years are similar. IHB may not have a huge amount of cases, but the department does successfully collect the penalties assessed. During the last council meeting, you were asked how many cases are currently open and how many of those cases stem from a consumer complaint. Did you get the handout? Okay. As you can see from the handout, there are currently 18 open cases, 10 of which stem from consumer complaints. Do you have any questions about the statistics presented today?
Roland Brown, you say there's 18 cases that are currently active,
Yes.
but then on the 2019, it says a number of cases open 23, number of cases resolved 15. So there's a disparity in the numbers. So how many cases are still active, I guess is what I'm trying to ask.
It is currently the 18.
18, so it's not the difference between 23 and 15.
No, because there's been more activity since that report was originally done.
Oh, I see.
Because we are now into fiscal year 2020, and those numbers would not be on the page 9, but they would be on the handout.
Okay, understand.
So Randy Childers, so on the bottom part of page 9, that for fiscal year 2018, the number of cases open is 18, resolved 24. I guess that's just some carryover from
Right.
other fiscal years.
That's why there's sometimes a little discrepancy, because things do sometimes go over to other fiscal years.
Okay. Any other questions, council? Morgan, thank you very much.
Thank you. Have a wonderful day.
Now we will move on to Regulatory Program Management Division.
Donna Lipke, I'm going to give the staff report for RPM. First, I have a personnel update for you. As you know, we lost Brian Ledbetter in May, but we hired a new person, Wallace Breton. He is very qualified for the job. He was former building official in the city of Fredericksburg, and he comes to us from ATS Engineering, which is an engineering firm here in Austin that does a lot of plan review and inspections for a lot of the smaller cities in the Central Texas area. So we're very happy to have him. He's been already contributing a lot to the program, to our inspections. We lost Carmen Marshall for the IHB program. We're sad about that, but happy for her because she's now the deputy elevator inspector. So that's a step up for her. And I just wanted to bring to your attention that Kelly was appointed to be a member of the ICC Offsite and Modular Construction Consensus Committee to assist in the development of 2 new standards for the International Code Council. So the International Code Council has partnered with the Modular Building Institute to jointly develop 2 new resources for the modular industry, and ICC 1200, Standard for Offsite Construction, Planning, Design, Fabrication, and Assembly, and ICC 1205, Standard for Off-Site Construction, Inspection, and Regulatory Compliance. She will be helping to develop those standards with ICC and MBI. She'll be attending her first in-person meeting in November. I also wanted to mention Rick Garza, who's a multi-program specialist that is assisting us in with our decal sales and permits, installation permits. He's been a big help in that because we tend to fall behind in that because all our people are usually out doing other projects. So, of course, we're very busy doing inspections. So I'm going to talk about current certification inspections that are ongoing. And Yvonne's going to give you an update on what's happening with our trying to obtain a better database and that sort of thing. So do you want to do that first? Or? Sure. Okay.
Hi, I'm Yvonne Feinleib. I'm the Building and Mechanical Section Manager. I'm Donna's boss, and I'm very, very lucky to have her. I really enjoy working with her, and I appreciate the opportunity to speak to you today.
I'm still planning to retire.
Don't do that. So we have not gotten anywhere that I can present you a project and do a demo, but we are internally having meetings, looking at demonstrations of software, discussing our needs, trying to find ways to be more efficient. As you know, we do not have any online presence right now. There are registrant lists posted on our website that are dutifully updated every month by Catherine Vaughn so that people can find who we are actually regulating, but we don't have a live search, and we don't have any way to pay online, and we don't have some of the capacities that might make us more efficient. So I'm going to talk about some of the things we're working on, but I don't have anything finalized for you yet, okay? When we have something, we will obviously bring that to you. So we're looking at plans. We're looking at a couple of different things. One is, can the plans that come in regularly from our DRA, the plans that are after they're certified and the third parties are doing all the inspections, those plans are coming in paper format. Can we get them electronically? They're too big to get with our regular software. You couldn't just email those plan sets to us. They would exceed the size. that our email system is limited to. So we're looking at a process to bring them in similar to an FTP server, a file transfer protocol, where they come as one big file and we can handle them and save them. We're hoping to do a pilot in the near future. This is with some software we have internally for moving large files around. If that pilot goes well, we will hopefully expand that. There will be no cost to the DRA for doing that, and it will enable us to stop having huge file drawers and boxes full of paper plans.
If I may, back in a meeting January of 2018, we were talking a little bit about this, and one of the great concerns at that time was that there was not enough storage for documents to be saved, and that was a budgetary concern, but an important one. Has there been any movement on the state side in helping you find funds to have a more robust database?
It appears, okay, now, this is a project that would not go into our existing database. This is a project that would hold those plans separately in the same way that we physically hold them in paper, okay? And having the space apparently is going to be possible. Obviously, technology is always advancing, and our opportunity to obtain storage is part of the pilot. How big are these plans when they come in? And how many when we look at how many we get, we don't know exactly what the average size is. So that's going to be part of our pilot to make sure that that is affordable. It appears to be right now, but we won't know for sure until we do the pilot. So we're going to try with one DRA for maybe a month or two and then reassess. So they'll be in a temporary storage area that doesn't cost us anything to make sure we can afford to pay for the storage ongoing, because we have to keep them until the next code cycle. Okay, so that's something we're working on.
Thank you.
We're also looking at the issue of plan review. So these would be the plans that we are actually going to need to look at before the plant certification. And we have another program, the elevator program, that is also looking at the issue of plan review. They're also getting their plan review documents in paper. Could we have a way for them to not only come in electronically, but then for our corrections to go back out electronically? That would be faster, it would be easier to keep up with, it would be more efficient for everybody. However, that is not a system that we have right now, but it's something we're looking for. And with it being more than one program, that may help us with efficiencies in terms of finding a good solution. We're looking at the issue of inspections. And again, the elevator program's looking at this issue as well. When we get an inspection report in paper, there's going to be so much information we can enter into our system. There's going to be the ability to save that paper document, whether we save it electronically because it was emailed to us, or we get it by mail and we scan it in. If the inspector could enter that data, instead of typing in most of the information, it should autofill, and they would only enter in what the actual details were. This is the unit I inspected, this is the date, if they found deviations or not, this is me, electronically sign it, boom, and then we would have that information. That is something we're looking at systems for. And again, we do not have a product identified and committed to. We do not have everything in place, but that's something that we're working on. We've identified as a long-term need to make the program more efficient. That would also enable us to produce statistics for you on our inspections in a way that we can't right now because we can't get everything data entered. We're looking at a couple of things for payment, whether we can get an online system to receive payments. So as you know, this program has variable payments, which means decals and insignia are currently based on the size of the product, the unit, the module, whatever. You're also looking at variable amounts of money coming in for certifications. Estimates for the cost of performing the plant certification, ways to reconcile the amount paid versus the amount owed, permits. We would like an online system where we could set up the bill at exactly what that amount owed was, and then it could be paid electronically to us. We did explore the idea of doing that with a phone payment system. We didn't get very far with that. We do seem to be making some progress with the electronic version. Again, we're not final on it. Texas.gov is our solution for the state that we generally use, and we're working on identifying a way to receive payments so our staff aren't carrying checks around. I do want to let you know that these things that we identified are not the only things we need. It would be nice to have a new database. It would be nice to have some capacity in terms of pulling reports and identifying issues through automated reports. And I'm sorry, I have not made any progress on that issue yet, but we are clear on the fact that over time, we do need to migrate to a more complete system. And I just want to let you know that we know that there are things that we can do and we will do eventually. And we're going to keep you up to date on it.
Is eventually more of a resource question?
You know, I don't know how to talk about that clearly because resources aren't just money, they're time and people and priorities, and you can't do IT projects wrong.
Right.
That is worse than not doing them. You have to space it out and you have to choose your priorities carefully and implement effectively. Our agency's done some really great things with IT projects. We did a project with our architectural barriers program to create a system called Tabs so they could do a whole lot of project entry and assignment online. It's been tremendously useful. The amount of boxes that we have not had to store anymore, just boxes and boxes of submissions, it's amazing. So I'm working on it.
I'm Marcella Rhodes. Why couldn't you do the same thing as Tabs?
So if we were to request and be approved for a project like Tabs, we could.
I mean, but it's the same, I mean, the system could work the same for you guys, wouldn't it?
Possibly. There would be some different moving parts because there are more pieces. The IHB program is an entire industry. So if you think about it from when the plan gets approved, it's not in any way attached to a decal. It may never get built. If it does get built, it may get built in a modified version. So all the different pieces as our regulatory process goes through would have to be identified, who would submit them, how would they submit them, how would they correct them, and to do that in a way that was very efficient. Tabs is just one particular entity, our RAS specialists. So, I mean, it would be a lot of work to do it properly, and we certainly wouldn't want to burden the industry. I know that there's the opportunity to grow, and we don't want to be any kind of drag on that.
Thank you.
Sure. Thank you very much.
Thank you.
Okay, I also wanted to mention that we're also going under sunset review, and I made presented an IHB overview to the sunset staff members on October 24th. The presentation included a brief history of the program, who we regulate, RPM staff activities, council contributions, program challenges, ongoing RPM, and program efforts and informational IHB resources. So we've been really busy. I'm going to show you inspections next that have completed. So I'm going to try. This doesn't seem to be working. I can get the mouse.
Randy Childers, just for no additional pressure on you.
Well, thank you.
All the information that you listed earlier, a lot of cities are doing. So if we can do it, I'm pretty sure y'all can do it too. Somehow, somebody, electronic plan reviews, receiving electronically, issuing permits electronically, taking payments electronically, receiving submissions electronically. If we can do it, you can do it too.
Did you build those systems in-house? If you purchased something or if you built it, would you mind emailing
Yeah,
Donna so we have some?
We use a system now called InterGov. That's part of Tyler Technologies. And I know Susan probably has some system, there's different systems that do that, but we also receive a massive amount of paper. And then there's Then there's the open records and keeping paper and trying to figure out where it all is. So
Our
we've got a
open
lot of-
records person will love you for saying
Yeah,
that.
so we've got, oh no, it's a huge thing for cities. I know it is for Waco. I can't imagine it's not for most cities. Electronically is, we would like to get to zero paper, which is not really possible, but we've made some big strides in eliminating, people pay with credit cards, do it online, and it's kind of like going to Amazon. You just buy what you want and pay us, and we move on.
Certainly what we would like. Just for people new to this program, like Marcella and Suzanne was here at the last meeting, but just a brief description. Our program, they're constructing an entire building. They're looking at the structure, the mechanical, the plumbing, the electrical, everything in the building. And each modular section of a house or building or component gets what we call a certification label. So we track all those labels, all those individual pieces, and there's plans that go with that. And those plans don't necessarily identify those buildings by the serial number that is assigned by the manufacturer. So there's a lot of moving parts, and that's why TABS doesn't totally work for us. So anyways, this first slide shows the inspections we completed since the last council meeting. I think as you can see, well, they're all integrators or equipment building manufacturers. So we've been really busy. Summer is usually our slow period for inspections, not this year. We've been busy the entire summer. We are scheduled out through November and into December already. This just shows the ones that are ongoing, and the ones that are scheduled through the end of this month. Didn't have room to show everything that's already on schedule. Again, as you can see, a lot of it's equipment buildings. We do have Z Modular and Falcon Structures going through certification now. So those have been interesting ones, especially the Falcon Structures, because they're using containers. They use containers for their,
I know, who's Falcon Structures?
that guy sitting next to you.
Oh, yeah, that's right.
So, we did 100% inspection for somebody who had needed to get this building. They had a deadline to meet. So they are planning to go through certification and get certified to build for Texas, but this was 100% inspection under our procedures for that. And these are just various reasons why these manufacturers that have started inspections aren't completed yet. The first one for most of these is they're not far enough along. We haven't seen everything we need to see for the inspections. So. Okay, trends and statistics. I need to move this so I can talk easier. This shows the total modular units constructed by use for different fiscal years. As you can see, for fiscal year 19, which ended August 31st, is up over 1,000 units from last year. And I expect it's going to keep growing, especially now that we don't have height restrictions on the program. So this is just a chart showing what we have by use. Offices are still the #1 building constructed under the program. Equipment buildings is starting to get up there too, though. I mean, it's starting to overtake classrooms. So this is just a count of how many units have been reported as completed, labeled, but they haven't been shipped yet, so they're not on site yet, at least at the time of this report. And this shows you the total number of inspections for fiscal years 13 through 19. As you can see, we are up, well, not on the number of facilities, but definitely on the number of units inspected. And again, I expect that's going to go up. I think the reason the number of units aren't up as high as these equipment buildings don't have as many sections, so there's not as, but they're more complex and they take more inspections sometimes. So, decal sales. This shows you the revenue for label sales for certifications. Again, it's increased. We're almost up to fiscal year 15 revenue, so it's increasing quite a bit. Again, just a chart showing you, commercial is still the highest one, equipment buildings is the next one, and industrialized housing really is the smallest number right now. So this just shows you the total number of decals sold. As you can see, it's up a little bit too from last year. Like I said, I expect that to go up even more. Now, where we're really, this is a chart showing you the total decals sold. Where I really expect to see a big increase is the revenue from insignias for components. We are like 4 times the amount of revenue from fiscal year 18 and 19. There's that many more components. Components can be just a wall section. We do have some that do these hospital units. I'm not exactly sure the details of that. We have jail cells and equipment buildings. A lot of times the equipment buildings, they're doing, one manufacturer is building the shell, so that's getting a component label, and then another manufacturer is finishing the electrical and mechanical. And that's when the certification label, the decal goes on. So it's increased immensely. Again, as you can see, the number of insignia sold has increased from 703 in fiscal year 18 to 2,058 in fiscal year 19. I expect to see that still keep going up too. So we also, I think the last meeting I told you about Pivot, what's the name of that? Pivot Tech, they do bathroom pods. So they're starting to build now bathroom pods for Texas.
Donna, this is Roland. If you would, just for the new members of the council, talk about the difference between what an insignia is and what a decal is, just to make sure everybody understands the difference there.
Yeah, the insignias go on components, so it's something that's generally not structural, except with the equipment shell, building shells. Those are obviously structural, but usually it's not structural, and it's something that's going inside a site-built building, or could even go in another modular building. So like, it can be a complete bathroom pod, or a kitchen maybe, or just about anything you can think of. Use your imagination on that.
Just a point of clarification before you go to the next section. This is Stephen Shang. On page 9, total modular units constructed by use. It's exciting to see from FY15 to FY19 that in Texas we've more than doubled the number of modular units constructed in that 5-year time frame, which is consistent with what's happening nationally. I'm just curious, as I look at that slide, on FY14 there was a big uptick at around 5,000, and it looked like that was driven by an aberration in the offices of like 2,800 units. Do you know what happened then where there were that many units back in 2014?
Fiscal year 14. Nope, can't tell you that.
Too far back in history.
Yeah, it's too far back in history.
But if we go from 15 to 19, it does look like it's doubling, and Roland, that would be consistent with what we're seeing nationwide, right?
Yes, it would be.
This is Marcella. Just clarify for me, the industrialized building or the modular building, is it considered a building or a piece of equipment by building code? Do we know?
It's a building.
It's a building, so it's just a different way of construction.
Yeah, and it might be built in
pieces.
and sections that go together to make up a complete building. Sometimes some of these portable classrooms or relocatable classrooms.
That's what I'm used to.
Yeah.
I'm used to
Sometimes those are just one complete building, but a lot of times there's also sections that go together to make a building.
That's actually what happened with one that I designed was 7 pieces, and they each had to have a decal.
Yes, each section gets a label.
Yeah, but it's one big building, it's just that each section has, yeah.
And each building has, or each residential unit has a data plate that has the information for that entire building, including the label numbers, the certification label numbers, the design loads on the building, all that sort of
But
information.
the building code treats it a little bit differently than a regular building, because it's, At least that's what my recollection was. But it's
Not-
it goes through the same process as a regular building, permitting, and maybe it goes through the ABE also.
They're required to, yes, if they meet that,
Right.
that threshold. But it's a little bit different construction process because it's in a plant, yeah.
Thank you.
So, this actually is on your agenda as a separate item, so we can, I don't know if we really want to, you might want to skip that item because I don't really have an update on, I don't
I
really.
would think so. Let's just use it as a placeholder for next time. I know our committee's got to work a little bit more on that.
Yeah.
So, yeah, I don't think that's, I don't want to say it's not worth spending the time, but based on where we're at and the limited power
And
that we have here today.
Because of the changes to the statute and rule changes that we developed for that, we didn't really have time to work on that anyway, so that basically was the update. So.
Okay?
Okay. Do you want me up here?
So does that get us to the executive office personnel
Oh,
updates?
yeah,
and
I
communication?
forgot, that's David. I'm trying to forget he exists right now.
Thanks a lot, Donna.
How soon they forget, right, David?
Yes.
Well, Mary Winston, TDLR, I'm going to start it off for exec, and then I'm going to turn it over. I'm going to kind of go in opposite order here, if that's okay. Going to start talking about our sunset review process. Sunset Advisory Commission is an agency of the Texas Legislature that evaluates state agencies and makes recommendations to the legislature on the need for the agency, performance of the agency, and any improvements to that agency under review. Currently, TDLR is under sunset review. Basically, the sunset process is an assessment of the continuing need for the state agency and its programs to exist, or any further action or ways to better the agency's handling of the programs that they regulate, or that we regulate. We currently have several members, and they're probably tired of me doing this, in the audience from the Sunset staff. If you've seen like synchronous heads go down and write stuff, they're in that back row. So they're just kind of coming to take a look at all of our different programs and sitting in on advisory board meetings, as well as presentations by different staff members and sections within the agency. On September 3rd, the agency submitted its self-evaluation report, and that is available on our website. The next steps, our review is scheduled to begin in October. It's already begun, and it ends in May 2020. You can visit the website for Sunset at sunset.texas.gov if you want any more information on the process. So they will be visiting with us quite a while.
Mary, this is
Yes.
Roland. If I could add, I'll take off this chair hat and put on my Modular Building Institute chair hat. Stephen Shang and I both are with the Modular Institute, along with our other jobs, right? And I'm currently president, and Stephen is one of the heads of our Government Affairs Committee. I've been in the industry for 40 years, basically, and helped Louisiana get their system started, which was emulated from the Texas system. And I deal a lot with states. I'm a builder and a manufacturer both in my real job, so I deal with a lot of states. I will say, this is one of the best programs there is in the nation.
Well,
And
that
we
is
want to keep
awesome.
it that way.
That-
That's
yes,
from
we do.
an industry standpoint. Stephen, if you want to talk, you've been very involved with the ICC from that aspect. But we feel this is a very positive for the consumer in Texas and for all the players that are involved in the industry in Texas.
Yeah, I would echo that. I think just given the scope of the Modular Building Institute, I think Texas is definitely one of the programs that people seek to model. We're involved in other programs around the country as well. We're in the California program. We're currently going through the Arizona program and in the Louisiana program. And I will say, working with Texas has been fantastic, and I think we should definitely strive to continue doing that, because these modular programs are a potential, if not one of the primary examples of how we can solve the affordable housing problems in our country.
And the Modular Building Institute is not only the United States, but it's also Canada. And we have, 6 7 international members.
That's right.
I believe. So we have a heck of a convention. If you want to show up, I'm sure you'll have a good time. It's very educational. But no, all positives to this program, and we want to keep it going in a very positive direction, as it has been over the last. I've been directly involved with it now, on sitting on this side for 10 years, but actively involved on the outside for the last almost 33 years. So this is a very positive thing, and we need to build on it and keep it going. Thank you.
Thank you so much, both of you, for those comments. I wanted to piggyback a little bit on the customer service numbers. We try to get information any way we can, every which way. It's not necessarily scientific, but the numbers that we gather it's just like raw data. So for the past 6 months, we've had over 30,000 views for our webpage for this program. It's about 164 a day. We also capture how the visitors to our webpage get to it, most from a desktop computer, 24% smartphone, 5% from tablet. The top reasons for visiting the site: registrant lists, forms, FAQs, administrative rules, and mandatory building codes. So we try to keep that data, and just on this end, to know what that traffic's looking like. That also helps us know, kind of gives us, like I said, not a statistical, scientific idea, but it does give us an idea of what Twan and customer service is seeing in calls and contact there. Okay, backing up to personnel updates, we are having several changes that are coming within the agency. Carla James is our Deputy Executive Director, and she is retiring. Actually, Friday is her last day. So we want to wish Carla the best in retirement, and she's doing it right. She's like young and active and planning all these things when she goes. So we hate to lose her, but we're happy that she's going. We had already hired Mike Aris-Mendez, and you were notified of that as our other deputy. At your last meeting, we're keeping Mike, but as Carla likes to say, it takes 2 people to replace one Carla. Because of this, we have now hired, beginning December 1, 2 additional deputy executive directors. One is Ms. Christina Kaiser. She's currently the director for our enforcement division. When I started here several years ago, I started off as a prosecutor in that division. Christina will do a fantastic job, and she has a lot of longevity with the agency. And our other deputy executive director is Mr. David Gonzalez, who has led the compliance, now RPM. I think he's worked here longer than Christina. He has a wealth of knowledge of the agency in general, and the building and mechanical programs in particular. And he's also a great addition into his role, and I will turn it over to our latest Deputy Executive Director, Mr. David Gonzalez.
Presiding Officer Brown, council members, I'm very honored to be elevated to the executive office. I've been here for 23 years and been able to contribute, but it's because of the staff that we have here. I did want to interject in this part of the presentation because at the last meeting, y'all actually asked of exec, what do we need in the way of resources? What do we need in the way of staffing? And as you saw really quickly, Donna was ready to scratch my name right off the top of the organizational chart, like I've abandoned them, but I haven't abandoned them. I'm still here at the agency, and I'm still looking out for their interest. I handed out before the meeting started something that's entitled Regulatory Program Management. That is our current organizational chart. My responsibilities actually don't go into effect until December 1st. That position has already been posted for the RPM director, and I expect they'll get around to interviews pretty soon. But I want to bring to your attention is the resources that we have dedicated to industrialized housing and buildings. For some time now, we've had 4 FTEs, full-time equivalents, dedicated to IHB. Donna Lipke, Kelly, and Catherine Vaughn are kind of fixtures. They've been here for a while. Mr. Britton is the replacement that we have for Brian Ledbetter. Those 4 positions are dedicated to industrialized housing and buildings and will stay that way. They have been that way. Our executive office, because we've been asked to do so many things with less, as Randy put it at the last meeting, we've wanted to stay nimble. And so instead of apportioning any particular FTE to a program, our solution has been to come up with multi-program specialists. At the very bottom of that same column on the left-hand side, you'll see air conditioning, electricians, elevators, industrialized housing and buildings. Just about any program we can come up with, we'll put it into that multi-program specialist position description. And we have benefited from individuals actually developing from within the agency. Chrissy Cooper, who actually came from our architectural barriers program, we convinced her that she had some opportunities and she had other skill sets that we could make use of. She has been pretty much working full-time on IHB for some time now and been a great contribution. In addition to Kelly and Catherine Vaughn, Donna Lipke always plays her part and directs traffic for all of our staff. You'll see two other positions below that. One of them is a vacant program specialist position. That's the one that Carmen Marshall used to fill, and she was doing double duty, working on both elevators and IHB, also contributing to the workload in industrialized housing and building. But since she's been promoted, we're trying to fill that position. I'm going to do another shameless plug like I did last time, and we actually had good luck by Mr. Britton fulfilling that position that we did the shameless plug for. Hopefully that'll work again. But I expect that program specialist position will also be working on IHB predominantly. Again, where our needs are, we're trying to stay nimble. If the workflow increases, as what we've seen from the reports that we're getting, we may have to revisit these numbers. I really appreciate, Mr. Chang, you provided me some MBI numbers. We've been talking about, and y'all have seen the numbers from our reports, that removal of the height restriction, it's looming large. Our executive office is aware of it. We're going to be monitoring the workloads, and I will tell you, we may need to take a picture of that back row over there, because I can't remember the last time that I've seen all three of my staff that are usually on the road traveling in the same place at the same time. Usually there's at least one of them out doing a certification, so it is a big deal. We do have a lot of work, and we're trying to be creative in how we address it. Mr. Nielsen's also on the list as a multi-program specialist, but he's actually been serving as assistant for our air conditioning program, which has had a substantial workload and volume. Again, we can use these individuals. The goal was to post these positions that have varied backgrounds and allow them to develop and grow and get the certifications necessary to do the job. As Donna points out, this is from foundation, electrical, plumbing, everything included. It's very difficult to find the Wallace Brittons out there that already have all the certifications and come into us willing to be public servants and do the travel that's necessary and deal with all the things that we have to deal with traveling the state and the nation. So we're hopeful that this plan is going to continue to work, but with the numbers y'all are showing me, I want to keep seeing those numbers so that I can keep putting them in front of executive and say, okay, the numbers are going up. Do we need to shift? Do we need to look at some of these other specialist positions in our other divisions or maybe in the RPM division and see if they can't be better accommodated in the building and mechanical section? So that's been our strategy. If y'all have any wisdom and guidance, and I'm going to put it back to staff to continue to look at other programs in other states to see how many staff, if they have a cadre of inspectors or if they're working on very stretched out staff like we are, because it is hard to find these individuals. Even if we post a position, they've usually gone unfilled for some time because we have to compete with the private sector, with the Randys and the Scotts, who may be able to pay a little bit more, or maybe they have some more incentive because somebody lives in their town. Yes, sir, Mr. Shane.
David, again, congratulations on the promotion, well-deserved.
Thanks, sir.
Would you talk a little bit more about the nuance in recruiting for a multi-program specialist versus someone that is just specialized in the IHB program like we talked about?
Sure. So when we've posted positions in the past looking for certifications already found, we've been unfortunately disappointed. There's either been a very small pool or zero applicants. Mr. Britton and Mr. Ledbetter have some exceptions in the recent past, and that may be something we have to explore. If there's a new market, especially if we want to expand horizons and maybe even go beyond the Austin market, if we can embrace the telecommuting, which our agency does allow for some positions for telecommuting, and we can expand our horizons on where these people might be placed, we might be able to get a better pool of applicants that are willing to travel the nation and do their work that's associated with IHB. But for the multi-program specialist, we're looking for a position that has background in elevators and architectural barriers, and when we actually come up with the matrix to decide on who gets the interviews, if they've got some experience in those categories, they score a higher point and they're more likely to get interviews with us. Unfortunately, the multi-program specialist position, very few applicants for that one as well. We're trying to broaden our base, get more interest, and in fact, we haven't had a lot of interest in that one either. And I suspect it has to do with the pay, it may have to do with the travel, and it's a competitive market out there. Does that help you a little bit?
Definitely.
Okay. That's all I had to report. I was going to turn it back over to Ms. Winston. I just wanted to let y'all know that we are watching the numbers. I do know, I love my staff. I appreciate the work that they put in, the travel that they give. And so when I don't see them so often, it does remind me, I need some bodies here to coddle me, to make me feel better. But they work really hard, and they're the ones that have kept up with this. I agree with you, Mr. Brown. Texas has something to be proud of with our IHB program, and I'd like to keep it that way. So executive is watching. I know they'll be listening to us. I know Mr. Francis isn't here today, but he'll be listening to this later, and I know that y'all's input is important, and those numbers, as they grow, we'll be watching them. Thank you.
Okay, Presiding Officer Brown, the next several items require action from the board, which from the council, which we don't have a quorum, so we can't take it this time. We can proceed as you wish. You can read them off. You can table them for a later date. It is your choice as to what you'd like to do.
I feel it best to table it for the next meeting.
Oh, I'm
Yes,
sorry.
ma'am.
Molly just whispered. So for G, you're okay with tabling that?
Right.
Okay, but Molly does want to go through the discussion.
Right,
Of the
the
rules.
rules. So actually, I'll go ahead and move
to the
where
podium.
Donna is so we can. Figured you wanted me up here too. Molly Fudel, Assistant General Counsel. So typically, these rules are something that we ask for your vote on before we go ahead and publish. But these rules are geared towards bill implementation, and we're on a timeline. We want to go ahead and get all this adopted so that our rules match our statute. So I'd like to go through them and get your input. Donna's going to help me. I'm going to take a stab at it, and she can interrupt me when I get it wrong. So just please interrupt me if you have any input or any questions as I go through the proposal. So you'll see that these rule changes implement two bills. One is HB 1385, which removed the height restrictions for the structures that fall within the IHB program. The other is HB 2546, and that was the bill that allowed manufacturers and builders of single-family housing to construct to the energy code with local amendments and alternative compliance paths that have been approved for the climate zone where the house will be located. We also put a few clarification and cleanup changes in here since we're going ahead and doing the rule proposal. So the first few changes I'm going to go through have to do with the height restriction, and they are essentially designed to ensure that the people who are working on these taller structures have the necessary knowledge and expertise. So in 7022, let's see, C, F, we are requiring the fire safety reviewer of the DRA to have certification as a fire plans examiner from ICC rather than just a building plans examiner. In 7023, for the third-party inspection agencies, we would require the supervisor of inspections to have certification as a fire inspector 2. On the next page, under 4, an inspector who performs an in-plant inspection of modules or modular components that are going to go on a project that's over 75 feet in height would be required to have ICC certification as a fire inspector 1 or 2. In 5, if the inspector performs an installation inspection of industrialized housing or buildings that are over 75 feet, they would be required to have ICC certification as a fire inspector 2. Moving on to 70.24, this is the third-party site inspectors. So in B5, we would require that the site inspectors have ICC certification as a fire inspector 2 to perform the installation inspections for these taller buildings. The next page is 70.25, the section on permits. So in this proposal, we're requiring, or we're essentially saying we're not going to issue an installation permit or alteration permit for a structure that's taller than 75 feet in height. Instead, the builder will have to be a registered builder with us. In practice, they probably would not be getting installation permits for these types of structures because installation permits are only for buildings or houses that are going to be owned and occupied by the permit holder. So if it's a very tall building, they probably wouldn't be owning and occupying it. But we thought it was important to go ahead and put it in the rules. In 7030, the exemptions, we went ahead and removed the exemption that corresponded with the height restriction in the statute. In 7060, subsection I, this also relates to the height restriction. We're essentially saying that a manufacturer who wants to construct modules or modular components outside the scope of their current certification is going to go ahead and have to do a certification update for those aspects of construction that they don't have a certification for. This is a current requirement, but we wanted to put it in the rules because as manufacturers want to build for these taller structures, they're going to have to do that certification update because we have not been doing certifications for taller structures because we just didn't have the statutory authority. Moving on to the next page, 7070. This first change in B9 has to do with HB 2546. That's the bill relating to the energy code for single-family housing. And in this change, we are requiring the manufacturer to provide the DRA any information related to local amendments or alternative compliance paths that are approved by that bill. Further down the page in C9, we have a clarification. This, I'll see if I can explain it, and Donna, go ahead.
I can explain it.
Okay, go ahead.
So, we're changing the article referenced in the NEC for the electrical test. Further on in these, we'll be talking about an amendment to the NEC. Currently, those electrical tests are only mentioned in the section of the NEC that has to do with manufactured housing. We get a lot of people saying, well, why do I have to do that? We're not manufactured housing. So we're adding an amendment to the NEC under manufactured buildings that includes those testing because the council years ago said they wanted those tests completed in the plants. So we're just kind of clarifying it so people will understand, yes, it is required. So that's.
Thank you. So on the next page, we'll go to 7073. This is probably the section that has the most changes. You'll see in subsection F, we have essentially described the minimum inspection requirements differently, and this has to do with the height restriction being removed. You'll see in the existing F1, the strike-through language, it says the on-site inspection is normally accomplished in 3 phases. Well, with these taller structures, that's not going to be true, probably. They're probably going to take a lot more than 3 phases of inspection. So what we wanted to do was describe the inspections in a way that applies to all of the housing and buildings falling under the IHB program. So in 1A, you've got the required inspections that are in the mandatory building codes. B, a set inspection. C, special inspections. And D, a final inspection. Under F2, at the very bottom of the page, we extended the deadline for completing construction for structures that are not built according to the IRC. So if a structure is built according to the IRC, the existing deadline of 180 days is still going to be there. If it's not built to the IRC and it's more complex, the deadline is going to be 365 days to give a more realistic timeline for completion.
And Molly, this is Roland Brown. This would be for a building that's not falling under a local jurisdiction at installation.
Correct.
Okay. So it's not locally permitted, it would be out in the county somewhere.
Correct.
Okay, thank you.
All right, on the next page, subsection 3, this is a clarification of existing language. We're talking about equipment buildings where site inspections are not required. We get a lot of questions about this, and so we put in language that's a little more precise than what's already in there. It's not intended to be a substantive change, but to be clearer to everybody.
And it's also the definition that we've came up with in the rule review process that the council work group has looked at. It falls in line with that definition. So basically, we're just putting it in there to clarify things for the buildings, for the equipment building manufacturers.
All right. In subsection 5, you'll see there's a cleanup change where we added in inspection agencies. They are already involved in inspections, obviously, so we're going ahead and putting that language in there. You'll see also a strike-through where it says additional inspections will be scheduled as required for larger structures and to correct violations. That language is essentially already, well, it's earlier in the rule where we re-described the inspection requirements. So in 5A, that's another cleanup where we're adding in inspection agencies. 5B, special inspections, this also relates to the height restrictions. We're requiring the special inspections be conducted by persons who are approved in accordance with your procedures, council procedures, and who meet the qualification requirements in the IBC or as required by applicable state laws. We're also requiring that the people who perform the special inspections not be changed once that inspection has begun unless department approval is obtained. In subsection 6, these are more cleanups. You'll see that the current rule requires that inspection report violations be documented on the violations report form. We're changing this so that it says they must be documented in accordance with council-approved inspection procedures. That is to give the department more flexibility if in the future we go to an online reporting system, or if we even wanted to change the name of the form. On the next page at the very top, you'll see that same change. We're going to inspection procedures approved by the council instead of the violations report form. Then in subsection G, we have a section, this is a clarification about destructive disassembly. Sure, go ahead.
So basically, this is defining destructive disassembly as related to what's actually built in the manufacturing facility. It's saying you can't destroy those to do an inspection on site. But what else? If there's other construction that has been covered up before the inspector was called to look at it, that's the jurisdiction of the local authorities, or if it's outside cities, then our inspectors can say, you need to cover that up. So basically, we're just clarifying that.
So the last section is 70.101. In subsection H, we added a section relating to the International Energy Conservation Code, and this mirrors the new statute that comes from HB 2546 relating to the single-family construction. On the last page, subsection J, this is what Donna was talking about with the new subsection of the NEC, and this lists out the required electrical tests, and this is a clarification. That's it. I know it was a lot, but we're available for any questions.
Yeah, it's too bad we've gone years without a meeting where we didn't have enough people for a quorum, so this is kind of an unusual event. I'm sorry that we can't vote on these today. So, Any
Yeah,
questions?
I can sit here and go, yeah, that sounds all great to me. There's no surprises here, right?
Yeah.
From what we've talked about in the past, but yes, we can't vote on it.
In some other
So-
instances, we have gone ahead and published rules to stay on a timeline. So that's something that we might go ahead and consider with this rule packet. And it will come back to you with the comments, the public comments.
And also, if you have any questions on any of this stuff, or you have any suggestions, we could consider those too. So,
Yeah, I know we're just dealing with opinions. I definitely would go ahead and publish it. And let's get through the comment phase and we can vote on it again.
Okay. Okay. All right.
Sounds good.
Thank you.
Thank you, Molly. Okay, that gets us through H, correct? Does it get us through I as well, Donna?
yeah, we can't vote.
Yep. And we can't vote on third-party inspectors, correct?
That's correct.
Does that cause problems to the third parties?
No, it doesn't.
Okay, so they're allowed to perform their duties even though they're not official through the council yet?
Yes, because the council gave us the authority to grant interim approval.
Good. Good. So I guess that takes us to recommendations for agenda for the next council meeting. I guess we can throw things like that out on the table, but it sounds like the next meeting, we've got some catch-up to do.
Yeah.
So, sounds like our agenda needs to be what it was today.
And I think we're looking at another meeting in March. I think that's the timeline that they were trying to do to get these rules approved and updated officially.
Based on what we just decided to go ahead and publish, I think that still works, doesn't it?
I think so, yes.
All right, let's shoot for that and hope for a better turnout.
Yeah, I'm going to remind all those people that didn't attend today what happened. I'm going to let them know. Because like I said, I think it's been, I can't even remember the last time we didn't have a meeting because we didn't have quorum. It's just,
I've been sitting here for 10 years, and there's never been a time we didn't have a
yeah.
quorum.
It's my luck.
It happens on your first one.
I know, right?
So I assume that you'll be polling us as far as a possible date for that?
I'll be polling you, or our council support people will be polling you.
Okay.
Chairman, we've been over here scrambling. It looks like early January is when we need to meet, and this will give Molly time to publish and get comments, and for us to have a quorum, and to go from there. So, with January?
January 6th.
The week of January 6th. Not the 6th, apparently, but the 7th or 10th. 7th, 8th, I'm sorry. 7th, 9th, and 10th are available in January.
None of those are a Friday, are they?
No Friday for you?
Okay, because we have one council member that said he'd only serve if he didn't have meetings on
Well,
Fridays.
we won't do that. We won't do that. 7th or 9th, we want to accommodate the council.
Okay.
January 7th, 8th, or 9th? Is that what you said?
The 7th
Yes,
or 9th?
7th, 8th, or 9th.
We're
No,
not-
7th or 9th.
Randy Childers, we're not picking today, correct?
No, no, no.
We're
No,
just giving us
I'm
some
just-
dates.
Just
Placeholding
letting
it.
you know and have a little time to think about it.
I don't think we have enough people here today to pick a
Yeah.
date.
Nothing's going on.
Yeah, so we're just, and whoever listens, it's one of the reasons that we do record it for everyone who's absent and other stakeholders who are interested. It's on YouTube, so they'll know what happened in this meeting. They will get the guilt trip from Donna before she makes the phone call, and kind of tentatively know when the next meeting will be. And of course, the location will be the same, and we can work on those other things when we poll you a little closer to the date.
And Randy, I know you're retiring at the end of January.
Yeah, I actually thought this
However,
was my last meeting, but it looks like I'll be here one more time.
however, you do realize, once you're appointed by the governor, you're supposed to serve until you're
Yes.
replaced.
Well, my term is up, I'm retiring January 31st, and my term is up February 1st.
Yes, and as,
If he gets busy, then yes, because
I think-
I won't swear to my attendance after February 1st. I won't make any promises, I just won't.
duly
Miss
noted.
you.
You don't want to be the one that breaks the quorum next time.
Right. We look forward to seeing you one more time.
Yeah, there's no way that would happen again.
The only thing that could happen is weather. We've had a few meetings that have had to be rescheduled because of weather when they were in January, February, so.
Well, to everyone who is here today, thank you very much for being here today.
Thank
And
you.
I can't really officially say the meeting is adjourned, so I guess I could say the session is adjourned. Safe travels, everybody.